Good morning. I'm Ruth Glick, and I'm going to moderate this program on mediator-litigator dialogue. I am a mediator and arbitrator myself, associated with the American Arbitration Association. I'm a member of the ADR committee, which is of the litigation section, which is sponsoring this program, and also a former member of the executive committee of the litigation section. So was able to put together this stellar cast of litigators and mediators to offer some very interesting insights of what's going on in the field today. First off, let me introduce Rebecca Westerfield, a former judge and a founding member of JAMS, who has mediated and arbitrated thousands of domestic and cross-border disputes over the last 28 years. She has received various recognitions, including Chambers, and was named by National Law Journal as an ADR champion. Another prominent mediator is Jeff Kitchhaven. He is ranked in Chambers USA 2020 as one of this country's top mediators. He handles a wide variety of business-to-business disputes, including intellectual property, insurance coverage, and professional liability cases. Jeff is a prolific writer and comments frequently on mediation and its practice, and is often quoted in the New York Times and Wall Street Journal. And our two extraordinary litigators are, first, Neel Chatterjee, a partner in Goodwin's intellectual property practice, and he also serves on the firm's executive committee. He is an internationally recognized technology litigator and trial lawyer, and has a proven record in some high-profile technology cases, some of which you've probably heard about, one being the Facebook Winklevoss case, which, if you didn't hear about it directly, you probably saw it in the movie The Social Network, and another being representing the engineer in the Uber Google Waymo case. And last but not least is Terrence Evans. Terrence is the partner in the trial practice group of Duane Morris in San Francisco. His practice is concentrated primarily in the financial services industry, where he represents a lot of international, national, and community banks, loan services companies, insurance companies, as such. And so he is represents the big guys, I guess, in the finance industry, but more importantly to us, he is the new chair of the litigation section of the California Lawyers Association. So welcome to this extraordinary panel. We are now 7 months into COVID operations. We are meeting by Zoom and not in person. So let me first off ask Terrance, as a litigator, what has changed? What expectations have changed for you and your clients for resolving disputes?
Certainly. So there has been, in some instances, more motivation to resolve disputes, at least in the interactions that we've had with plaintiffs. A lot of them because of the financial circumstances involving the economy and its impact on the legal profession. They've been more motivated. We've seen to resolve disputes, to bring cases to resolution. Since it's so difficult to get trial dates, we've just seen an increase in motivation, and we've tried to use this on the defense side to our advantage to move cases more quickly to resolution.
I always thought defense would rather postpone it than have it resolved that quickly.
Yeah, I mean, from our perspective, we'd rather get 1,000 cases instead of dragging out 1 or 2 cases. So if we can quickly get matters resolved, we find that our clients appreciate that and they continue to send us more work. So we try to move them along as quickly as possible.
How about your clients, Neel?
So it's been a little bit of a mixed bag, but I have to say the anxiety that's created by having Zoom and web conferenced hearings on difficult issues, and the increased anxiety and uncertainty that's presented by that, like how does that affect the likelihood of a good outcome or a really, really bad one, has increased the appetite to resolve disputes. And it's really because of the notion of, when you have higher perceived contingent risk, you are more likely to want to manage that risk. And then the question arises is a natural discomfort that people initially have about doing mediations through conferences like this. Is, will people really be able to read body language? Will people really be able to understand what's really going on? And generally speaking, when you get someone to try it, they actually are finding it pretty useful. You lose some things along the way, but then you gain more things along the way. The other thing is that in terms of having the discussion with clients, both on the plaintiff side and the defendant side of what are you really looking to get out of this case? For some reason, there's more accessibility and availability in a COVID world than when it wasn't the case, when this wasn't our kind of normal operating practice. So having those kind of really important discussions to drive things to resolution, actually, I mean, the price tag you pay is you know, you're only 32 steps away from your bedroom, your living room or whatever, but the availability to have those conversations has actually increased in my experience.
Okay. Jeff, tell us from the mediator's point of view, have you begun to embrace this, and how is it going from you?
Oh, yes, we embrace it, because the alternative would be not to do mediation at all. And so in this new reality of social distancing, we're all learning. I think in the springtime, Ruth, things just came to a grinding halt, not only in the world of mediation, but in the economy and really the world as a whole. And I think that beginning in the summer, each month, we're building back a little more strongly toward the new normal, whatever that is. More mediations are getting scheduled, just as more court hearings are getting scheduled. And it's quite surprising. At first, I, like many other people, I was quite concerned about the lack of close communication, what would happen if we were physically distanced. But then when you think about it, think about the kinds of communications that we have on the telephone. I'm sure that all of us have had conversations on the telephone that have been quite emotional and quite intimate and quite personal, and they work just fine that way. And so it's becoming on Zoom, where as people may have their second or third mediation on Zoom, it may be their 2000th or 3000th conversation on Zoom. And people have adapted and adjusted to communicating in this new medium in general. And although it is different, I think it's still effective. I think we can communicate personally and closely in this new medium. And I think we're doing just fine. And I think we're going to do even better in the coming months and years.
How about Rebecca? Are you hugging your screen yet? And have you found any pushback from some of the clients?
I'm not exactly hugging my screen.
You're on
but
mute. Rebecca, I think you're on mute.
No, I'm not.
No,
Oh,
I can.
now I hear you. Okay.
Okay, thank you. So I'm not exactly hugging the screen, but I am enjoying it. And I have to say, I was a little surprised by that. We had the same experience that Jeff was just talking about. Early in April and May were probably the worst months we had for mediation. And after that, every month since has been as though nothing has happened, and we are fully booked. We are very, very busy with mediations. And I think that the whole new use of virtual platforms has really required a flexibility, a nimbleness, and it's a call to creativity. And I've seen a lot of creative ways of approaching mediation, the mediation process, that in the past, folks were sort of in a rut. It was, well, let's just have our one day and that's it, and then we move on. Now folks are thinking a lot more about staging their mediation process. They're much more attentive, it seems to me, to preparation, which in a virtual platform, I think preparation is really, really key. There's more reaching out to the mediator before the mediation process, not just about the logistics of the platform itself, but about substantive issues, about personality issues, about whatever has been an obstacle to the closure of the litigation before the mediation. So I welcome it. And I think it's been, frankly, I think it's been a breath of fresh air in the whole mediation world.
Yeah, anybody run into problems with confidentiality? Because now we're on a whole new platform.
So if I can answer that, at least I'll throw out some issues that have arisen and how we dealt with them. In my experience, the clients are anxious about the confidentiality issue, particularly because when Zoom first launched, there were a lot of issues of Zoom bombing and this and that, and people getting anxious about it. And then what really became a big issue, and I'll be interested to hear what Rebecca and Jeff have to say, is having opposing counsel or the opposing side suddenly come in at an unexpected time. And so what I've done on several of my mediations is we give the mediator a piece of paper that has 3 sets of links. And it's basically what you would do at a mediation facility. One link is the room for the plaintiff. One link is the room for the defendant. And then one link is a caucus room. And they're all organized by the plaintiff and defendants is by each party. And then you'll have one person kind of organize the caucus room. And so there's no way to access it because the other side doesn't necessarily know what your link is, but the mediator does if they're going to come in. And the mediators developed a protocol to send an email saying, I'm coming in now before they come in. And that has worked very, very effectively. We also did one where we actually operated the private caucus rooms on separate platforms. So one party used Zoom, another one used Microsoft Teams, a third party used WebEx, and then the caucus room was all in Zoom. And so there are various little tricks like that. You just have to think about how is this going to work ahead of time and what are the concerns.
Do you need different computers or different screens for that? How do you work that?
The remarkable thing is that you don't necessarily need different computers, but the way Zoom works is if you go into one room, you leave the other. So one of the things that we did was most people had iPads. So if they were going into the caucus room, they'd use their iPad. And if they were in the joint room, they'd use their laptops or whatever. Or people could even use their mobile phones.
So I just had a Zoom conference call this morning, and one of the attorneys got up he was in the office to talk to his secretary. He had his headset on and his microphone, so we could hear everything that he said. So you have to remember when you're using even the same platform or different ones, remember you might be hooked up. Like I see, Jeff, you've got earphones on. How do you ensure some of the confidentiality in your mediations?
Practice, practice, practice. As mediators, I think we've all become pretty nimble and agile at whipping people in and out of different breakout rooms in Zoom. The things that Neel suggested are just great. And I have had people using Slack and Teams and WebEx as kind of side platforms for their internal conversations among their team. Because in mediations, there are times when people want to have conversations of which the mediator's not aware. There are people keep secrets from mediators all the time and have back channel communications. So it's just fine that people have developed those ways of doing that. And again, most mediators, I think, are pretty good at keeping people in and out of different breakout rooms in Zoom. The concern about Zoom bombing and anarchists coming into our mediations and showing pornographic pictures and things like that. You hear about that with city council meetings and other public sorts of meetings. I've not heard of any mediators having those particular kinds of problems. The other confidentiality issues, though, are choice of law issues. When everybody's in a different state, there are questions as to which state's privilege or confidentiality law applies to your mediation by operation of law. And there are many states around the country whose courts will apply the law of the forum under the territoriality test and simply disregard the law that you chose to govern your mediation. So I think people need to be more careful about confidentiality in the online era. I think confidentiality agreements are less effective in protecting confidentiality than they ever were before. And reliance on California law should not be as comforting as perhaps it was before in cases where not everybody, sometimes only the mediator or only one lawyer, is physically present in the case of physically present in California. So these are all things about which people need to think.
Yes, and I would add to that, if I might, Ruth, I welcome, particularly in large business-to-business cases, customized confidentiality agreements. That is not relying just on the JAM standard agreement, but agreements that really take into account the kinds of issues that Jeff is raising. I think it's absolutely critical. The other thing I would say, by the way, is just because people are on different screens doesn't mean they're in a different room. So we have had situations, of course, where plaintiffs are in the office of their lawyer. So they're in the same room. I, as a mediator, may want to have a separate conversation with that lawyer. And it's really important to set the ground rules from the beginning that there is availability where we can have an actual private conversation with the clients going to a different room or the attorney going to a different room. So even though we have the breakout rooms on Zoom, I think we need to also remember that screen does not mean that people are not in the same room with each other. And you do want to know who's in the room.
I was just going
Yeah, go
I was
ahead.
just going to add that a lot of clients are also concerned about confidentiality as it relates to recording. A lot of these conversations, a lot of these Zoom and other platforms can be recorded. I think it's, and I agreed with everything that Neel said. I think it's also good to maintain some independence. So for the mediations that we've participated in, we like to provide our own link for the private room that we have with our clients, and we can have better control over when the mediator is going to come in, as opposed to just using a link that is provided by the mediator. Another thing you want to be careful about is to make sure that your mute is off or your video is disabled when you're going from one room to the other. So I have 2 iPads and a laptop, and sometimes I have all 3 going at the same time. But I find that when you're having those private conversations with a client, sometimes it's better to just completely log out, just so that you know nothing is being recorded, nobody's overhearing, you don't inadvertently forget to shut your mute button off, and then you can log back in for those, those times when you just want to have everything completely private, and also maintain control over your own links as opposed to just using something provided by the mediator or some other party.
So certainly the confidentiality is something you have to be aware of all the time now using Zoom and other teleconference platforms. But let me also ask you about the distractions of working at home. Most of us are still in our home offices, might have kids running around, dogs, cats, and then someone starts making dinner and it smells so good and you, hey, let's resolve this tomorrow. Has that happened to you, Neel? I'll start with you.
Well, so at this very moment, I had to text my wife and ask her to take away my dog who decided to bark at the front door because the gardeners in the neighborhood have just happened to show up during the Zoom conference. and so I don't know if you can hear the leaf blowers outside, but I certainly can. So look, I think the development of the shelter in place is everyone recognizes that we all have life, that people have small children where they're dealing with some of the complexity of childcare at home, that people have pets. And, I tend to, when I meet with my team, or sometimes I've done it in kind of the caucus sections, does everyone want to introduce us to their pets? And I kind of make a light joke out of it because it's an acknowledgement that we all have these issues arising. The big issue is confidentiality. Like, I don't want my 7-year-old walking into a room where you're talking about this really intense thing, and then somehow they start blabbing it in some way that you don't want them to. So now my kids are older, but I know that's been a concern of some of my team members. And those are things that you do have to manage. It all goes back to confidentiality though, but like the informality of it all, I actually think the mediators do a great job with it. Generally, the parties have done a really good job with it. What is weird is when people choose very strange backgrounds on their conference, on the web conferences. Like sometimes you see stuff and you're like, not really sure that was a great idea for this particular event.
You kind of learn about people when you see them in their own environment. Does it change from the mediator's point of view? Does it change some of the negotiation because people are a little more comfortable sitting at their own desk and home? Or are they less engaged? Jeff?
Ruth, people are both more engaged and less engaged. And we try to use that to our advantage as much as possible. The fact that people are sitting in comfortable surroundings, as you can see, we're sitting in comfortable surroundings in our homes on this call. When people don't have to put on the suit of armor and gird up in the power tie or the power suit and drive into downtown of whatever city and take that elevator ride up to the 35th floor, when people have to go through that ritual, they can become more uptight, and it reactivates all of the thoughts and feelings that got them into this uncomfortable lawsuit in the first place. And so talking to people in the comfort of their homes has a tremendous benefit. And I think we can, in a sense, reinvent mediation for the better using this informality. I find that joint sessions and direct communication, people are much more open to having limited, modest conversations on discrete topics with each other from the privacy of their own homes. The people who are speaking tend to get less agitated. The people who are listening also tend to get less agitated. So conversations that would have seemed very confrontational when everybody's in their blue suit and white shirt and yellow tie sitting across the table from each other, all of a sudden, when your dog is next to you or your cat is on your lap or you can hear your children in the other room, people's blood pressure is just lower, and we are able to have much more direct communication between the parties and certainly between the lawyers than I think we were before. And I think that's very much to the benefit of the mediation process. When clients can see their lawyers in action, then the lawyers get credit for the good work that they're doing. And a lot of what we do in mediation is not only getting cases settled, but also cementing the attorney-client relationship as we go about that process. And when we can have clients and lawyers working at least virtually shoulder to shoulder, then we can increase that client satisfaction, and that's a good turn for everybody.
Terrance, are your big financial clients more at ease, more willing to make a deal at home?
I think so. It's made it less stressful, and what I mean by that is, in the old days before we had this virtual option, folks would have to travel across the country from the Midwest or from the East Coast, and there's good and bad. So I actually valued the time of being with the client. We'd go out to dinner, we'd have small talk, we'd have a whole planning day in advance. But now it's easier for folks to get back and forth without all of the travel that's involved. And we can do multiple cases. So sometimes we may have a couple of mediations going at the same time because it's all virtual, or we can put more mediations closer together because you don't have the big delays that were required with the travel. So in some ways it's brought us closer together. We have more FaceTime, we see each other more, and we're able to do things that we couldn't do before.
So it sure changes. I feel like I'm never going to do a telephone conference call anymore because Zoom adds so much more. We can see each other and I think connect, better. Rebecca?
I was just, there's also time for human moments. So just for example, we had a mediation, and right at the beginning when we were doing introductions, one of the other counsel's daughter came in and started singing happy birthday to herself, saying it was her birthday. singing and dancing, and we all loved it. And it created this nice environment that I think facilitated more meaningful settlement discussions. And we got the case resolved later that day.
Right, that's some good ideas, Rebecca and Jeff. You could
Right.
bring someone bring in a child to get
Well,
everybody warm and cozy.
What Terrance is describing is just the connectivity and the way it can really ratchet down some of the unnecessary, more toxic conflict. And I find people are less reactive. It also means they may be more rational, which means there's an intensity, I think, with this whole process that requires a more thoughtfulness and precision in some ways.
Can I just add one other thing, Ruth, that I think is one of the negatives of the remote work, which is when you're in a mediation that's really contentious, and sometimes it'll go long and you stay long in the day, and you're staying past 7 or 8 o'clock sometimes. And there's a natural pressure, particularly when people have traveled in, to kind of keep them there to get the deal done, and you feel like the deal's getting done. With the web conferencing that we're doing now, people get exhausted by being on screen for too long. And it doesn't, I have found at least that at some point people are just like, I'm done being on screen. And even if we were close, like I can't do it anymore. And I've seen some discussions, negotiations, and the like not happen just because of those logistical challenges.
And I say I agree with Neel. I've had many mediations when we would have them in person that would go to midnight. I think the latest one I had went to almost 3 in the morning. It was a big case. We finally got it done. The clients on both sides had flown in from across the country. They felt like they had come here, they came to try to get a deal, and they didn't want to go back without a deal. And there was a more intensity and a pressure because everybody was there and had traveled so far and invested so much to get there. When you're doing it virtually, you don't have that pressure. You don't have a flight to catch. You don't feel like you have traveled across the country. It's much easier to say, okay, we've reached our limit and we're going to cut it off. Whereas when you're there in the moment and everybody's there and they want to get a deal done and you're so close, there's a different type of urgency that you feel than when you do it virtually.
So while we can appreciate some of the maybe advantages that this epidemic has brought to the field of mediations in terms of using Zoom and using new platforms and maybe, some positive aspects. Let's just talk about mediation in general even when we go back to in-person mediations. Let's talk a little bit about what mediators and litigators expect from each other. And I'm going to ask Neel to start off the discussion. You've been involved in some very high profile cases with some of the biggest tech companies and big, bet the company kind of cases, and some, at least the movies, the news report tell us. But maybe give us some insight into how that works, the interaction between litigator.
Yeah, I'm interested to hear Jeff and Rebecca's view. I actually think that whether it's high profile or not, a lot of the things about mediations are fundamentally the same. Large companies that have large litigations, sometimes it is still emotion that is driving the decision making. Sometimes it's a competitive issue. Sometimes it's just money. And most people I know, when they write their mediation statements or they make submissions to the mediators, they kind of give all of their legal arguments about why they're going to win. And don't get me wrong, there may be a value for that if part of the goal is to get some evaluative characteristics, although mediators often don't like doing that. I think the right thing to do is to start your mediation statement about where in the process are we and what are the obstacles to settlement and what are the motivations of the parties? Is this an emotional case? Is it really we're fighting over what's the value of the case? Is it a strategic case? What are strategic in the sense that it's a competitor wanting to affect the behavior of another competitor? Or issues such as that. because I really think that the mediators, the way that lawyers engage best with their mediators is to view it as what are the drivers that have created obstacles to settlement so far. And it could be that no one's spoken. Okay, that's a useful thing to know. No one's spoken. If they have spoken and they haven't been able to reach resolution, what is each side's respective take on that, and why that occurred? Most people that I know, they kind of bury that at the end of the mediation statement. Whenever I talk to the mediators, they say that was the thing that was most useful for me. And so I think one way that lawyers can engage really well with mediators is include all the stuff about why you're going to win, but really focus on where is the failure. And I'm going to use that term, even though some people don't like it. Where is the failure to reach resolution arising from so far? And what are the drivers to breaking the logjam, without saying what you can necessarily, do or not do? And the mediator may agree with you or not agree with you on it, but those are going to frame some of the things that are really important in terms of what to address at the mediation.
Let me throw this to a mediator, Rebecca. Is it your job or the litigator's job to identify those obstacles to settlement?
It's both our jobs. So obviously we invite the litigators to let us know what the obstacles are, but remember the litigator is looking at from their perspective, and they only know what they know from their viewpoint. There's another party, or in many cases, multiple parties who have multiple perspectives. And it's up to the mediator to figure out, where has the disconnect been? Is there a failure of communication? Is this really a personality problem? Is this really a lack of information? I think that's the danger for litigators, not the good litigators who are here, of course, but for some litigators, is letting groupthink sit in. They have looked at this case so often, they have gone over it with their business folks so often that they believe they know everything there is to know about this case. And therefore, the obstacle to the resolution of the case is known only by them, perhaps, right? But the fact is, there's a lot of information and assumptions that need to be probed, and that is really the mediator's responsibility. I think it was George Bernard Shaw who once said, the greatest problem with the communication is the belief that you've had it. So the litigators may believe they've had this conversation already with the opposing side, but in fact, they're talking past each other and around each other. And that's for the mediator to identify and figure out the right timing on when to raise issues, share information, and move the parties into a productive conversation.
Terrance,
Ruth, Neel, if I may, Neel and Rebecca are so right in terms of talking about these issues, and the choreography of it, if you will, is so important. I live in Los Angeles, although now I'm handling cases increasingly across the country and really around the world. But in Hollywood, they would call this question, what is the backstory? What is really happening in the emotional lives of the parties? And these are things about which lawyers are not comfortable and not really experienced in many cases writing about. And that's why it's so important.
Am I the only one having trouble?
It's important for us, Rebecca, I'm sure you do this, to have telephone calls or now Zoom calls with the lawyers after we get the briefs and before the mediation takes place, so that we can ask these questions about the interpersonal aspects of things. I like to ask, what are the challenges that we face? What are your expectations of me? Tell me about the personalities of the people who were involved. And if lawyers are comfortable talking to the mediator about their relationships with their own clients, are they getting along well? Are there unrealistic expectations in the air? What are the issues not only between the sides, but the issues that may be going on behind the table between lawyers and their own clients? And these are the kinds of things that are awfully difficult to put into writing. And so I hope that mediators are routinely having telephone or now Zoom calls with lawyers before the mediations. And to the lawyers listening to this, if the mediators are not initiating those phone or Zoom calls with you between the time you get the brief and the time of the mediation, then please, lawyers, initiate those calls with the mediators yourself. We want to help you meet the challenges and solve the problems. And we can do a lot better job of that if we know what they are in advance and can give it a little thought.
Yeah. Terrence, I was going to ask you, how often do your clients really identify some of the obstacles and the issues and are able to communicate it to you? And how often have you been in a mediation where you've discovered something you didn't know?
Yeah, so sometimes it happens in both ways. And I also wanted to respond to the prior statements. I've been involved in a lot of very complex mediations where you have insurance coverage issues and you have defense issues. Some of the cases I've been involved with, there have been 30 or 40 parties, large construction defect cases, large IP cases. And so you have to deal with both the coverage issues, because if you don't deal with those issues, there'll be no money to fund a settlement. And then you also have to deal with the defense issues. I also have usually at least two versions of my mediation brief. So there's a mediation brief that we provide to the mediator. There's certain information that we want to communicate to the mediator, and there's certain information that we want to communicate to the parties. We're often trying to build alliances with different parties that we have things in common with. So on the insurance coverage issues, there are certain alliances that we will try to put in place before the mediation so that we know that there'll be sufficient funds to put together a pot of money for a reasonable settlement. And then there are also the defense issues. And I agree with what Jeff said just a few minutes ago. We always call the mediator before the mediation. And we say, okay, this is the mediation brief. Here are some of the coverage issues that will have to be resolved or there will be no settlement. Here are some of the defense issues. This is something that I think we need to communicate to these parties. Sometimes you'll want the mediator to communicate certain things to your client. There may be certain emotions involved that Neel mentioned, and sometimes emotions can get in the way of a meaningful settlement. So you'll want to put a bug, if you will, in the mediator's ear on how to deal with some of those emotional issues that could get in the way of settlement. So there are no surprises when we get to the mediation. And that way the mediator is prepared to deal with the client, they're prepared to deal with the other side. They know where all of the potential impediments to settlement are. So information usually comes in from all sides. We're usually pretty well prepared by the time we get there. But every once in a while, there's a bombshell that can be revealed in the mediation. Sometimes I'm the one, and I usually prefer to be the one that's doing the revelation of a bombshell. In one case that I had, it was an agricultural case involving coverage issues. And we found a statement that one of the principals had made to the press before they applied for the policy, showing that they were well aware of this potential exposure before they completed the application. And they didn't report it to the insurance company. So it was really nice in the middle of the mediation to go, wow, here you go. We have this statement that you made to the press and you didn't put it on the application. So you love those and you live for those kind of moments.
May I ask a question, Ruth?
Yes.
Of Terrance, why do you wait till the mediation?
Sometimes it's for a certain emotional impact. In this particular case, we didn't find the information out until shortly before the mediation. And we wanted to use it in the settlement negotiations, and we thought it would have maximum impact.
So I want to follow up, Neel, you alluded to some of these strategic litigation cases, and I wanted to ask you, what kind of mediation strategies work the best with that? What are you looking for from your point of view, and what do you want the mediator to do?
Yeah, so when you have strategic litigation, I would say the hardest thing to figure out is what is the strategic goal of the business, because a lot of times they're not gonna disclose that in the mediation.
Even to you?
They might disclose it to me, but I may or may not be able to disclose it to the mediator. One of the things that I've seen some mediators do, and this is kind of an old school thing, it's not as common today, is for the mediator to just kind of say, can you tell me the 10 most important pressure points for your business? And let's just write it on a whiteboard, or, now in a COVID world, we put up a screen on a Zoom. And let's just talk about the things that are, the biggest pressure points for your business. And then get the other side to do that, if it's 2-party or even 3-party, and to try and smoke out where are there points of alignment on the pressure on the pressure points of the business where they could add value to each other. It's difficult to do that and resolve the mediation resolve the case in a single day. And when it's strategic litigation, in my experience at least, it tends to be more of a process where you have one mediator that's invested. Everyone has these conversations. You spend a day and then you schedule a follow-up time and maybe provide the mediator with some additional information, and they come back. But, those cases don't typically resolve on a dollars and cents basis. There's normally some sort of a deal that comes out of it. And it really requires a lot of education about the core inflection points in the business.
Anyone else want to comment on mediating the cases that have strategic business considerations? They're a little bit harder. Usually it's not just about money.
I was just going to add, I've represented a number of real estate developers in mediation, and sometimes it's just not about dollars and cents. Sometimes there is a particular piece of property that has strategic business value or development value, and all the money in the world is not going to change what the emotional attachment is to a particular location or a piece of property. So sometimes I've been involved in partnership disputes where partners are separating and they're trying to divide the properties between themselves. Sometimes having a better understanding of how to align certain properties with certain business interests can help lead to resolution of the case, as opposed to just looking at what the market value is for certain locations.
Right. I think in these kinds of situations that I've been involved with, quite often the parties need to feel that the litigation possibility is not going to work, and they need to feel that that has been exhausted in the mediation process before they will open their minds up to redoing the deal or rewriting the agreement, or dividing up in a real estate development case I had, dividing up the different pieces of the deal. And then sometimes they believe they've exhausted the discussion about how to resolve the case just with monetary solution, and want to go to a deal making, and then the deal doesn't work, so they go back to litigation. It's a process, so I don't think there's one answer. I think you just have to keep pushing and kind of in parallel paths sometimes to try to find that point where someone decides, or both sides obviously decide, that they want to go one path or the other. But obviously it's a multi-stage process.
Yes, and Ruth, I think there's a lesson in there for advocates, that clients oftentimes come in all kinds of mediations with very high expectations and instructions to their lawyers to get the gold-plated solution. And we sit there as mediators and we just know at the beginning of the day that that's not going to happen. And the worst thing that we could do is to tell people at 9:30 or 10 o'clock in the morning, look, my friends, that's just not going to happen today. Let's get realistic here. We have to go through the process where the lawyer puts the best foot forward and does so in a diplomatic way and a forceful way too, or an advocate's way of doing it. And so I think advocates have to learn to be able to go back and forth between the gladiator role and the diplomat role in the mediation. And the lawyers on the receiving end have to know that there's some of this that just has to happen before we can actually get to the process of deal making. Let people exhaust themselves and spend themselves trying to get the gold-plated solution. Let them try. Who knows? Maybe it'll work. Chances are it won't. And then when it doesn't, we get that kind of mid-afternoon doldrum in the mediation when reality starts to sink in that, well, maybe this client is going to have to go along with their lawyer's good advice and look for a deal along these lines or those lines instead of the gold-plated solution that they began the day hoping to get. So there is a place for zealous advocacy in mediation, and there is a place for diplomatic deal-making in mediation. And I think mediators have to be prepared to allow lawyers to play both roles fully. And I think lawyers need to be prepared to play both roles fully as well.
Okay, I want to follow.
Can I just add something to what Jeff said? Because there's an exercise I have clients do before we go into a mediation when I know that people are looking for that kind of gold-plated solution, which I agree is hard to get out of a one-day mediation. Is I'll tell them, you will have to agree to a settlement that is on one page and ends with the phrase, "This is binding and enforceable and can be submitted to a court for enforcement." Why don't you write out a painful, acceptable result that you could put on a single page? And you know, there's a lot of emotion that goes into that exercise, but when people do that, they actually have a better sense of what they're looking for walking out. And when Jeff comes to me and says, we don't want something super complicated here because that's just going to invite a bunch of disputes and litigation about whatever the settlement was. You get to that one page, you know, sometimes it'll spill over into two, but it really helps when the client understands that you're not going to be settling the case that day with a 50-page settlement agreement.
If I could just add one point, one thing that I have found that has been helpful both as it relates to cases I've defended and dealing with folks on the other side is to understand what the implications of a settlement are beyond the case that you're working on. So sometimes there's other litigation, there's other positions the client may want to take in other cases, and depending on how this matter resolves, it could impact that. So it's always good to have a conversation with the client to find out if there are any other implications that this case will have. And one other thing that also has been very helpful is to make sure you've done your opposition research on the other side. I recently resolved a banking matter involving another firm, and we had done our opposition research, and there was an identical case that this firm had that went up to the Court of Appeal. They lost, and we were able to pull out that decision and show this is the exact same issue just lost on 2 months ago. Do you really want to push this all the way to trial when you're likely to get the same outcome? And that was effective. We were able to get that matter resolved very quickly. So do your opposition research.
And Terrance, when those matters that are extraneous to, shall we say, the four corners of this lawsuit are important, sometimes it's important to clue the mediator in because we may not be aware of those things and we may be putting pressure on people to make a deal that appears perfectly appropriate within the four corners of this lawsuit, but may be inappropriate once these other considerations are taken into account. So when selecting mediators, pick the mediators with whom you're comfortable having those kinds of conversations, with whom you're comfortable being candid before the mediation. This is what's going on with my client. This is what's going on with my client's business. The kinds of mediators with whom you have a feeling of trust that the mediator, yes, we're going to put some pressure on you, but we're not going to put inappropriate pressure on or pressure that's going to backfire. So in selecting mediators, the question of that trust factor is important, and it goes beyond just a mediator's academic qualifications or prior career path.
So before I ask my next question, I want to remind everyone this is a live program. So if you have any questions, go to the chat box and pose the question to everyone. Neel, I want to circle back to you because you've had those high-profile cases, some of which did go to court. What does success look like when you don't get a settlement in a mediation?
What does success look like when you don't get a settlement? Well, you win a trial. You win the trial, but one thing I think happens all the time is, especially in complicated or emotion-filled mediations, you don't settle at the mediation 99% of the time. It's normally a little bit of time afterwards when people have a chance to reflect. Maybe they get past the heat of the moment. A lot of really good mediators like Jeff and Rebecca are good at following up and saying, hey, is there anything else further that I can do? And it kind of provokes people to actually engage in a little more discussion and a little more creativity. And I actually think in many instances, mediated cases, they're successfully resolved after having been given the benefit of a little bit of time. Not a lot, but a little bit of time. Because if you give a lot, the litigation starts happening again and emotions flare up again.
If I could just add a point to that, there have been a number of mediations I've been involved in where the parties will agree to keep the mediation open for a period of time while we don't increase litigation expenses, just so that folks can continue to have dialogue under the umbrella of mediation. And I have found that to be very effective because, as Neel says, sometimes it doesn't all happen in that one day, but that additional time without incurring fees can be very helpful.
And I think Rebecca mentioned earlier that now you can stage the mediations using Zoom, right, Rebecca?
Yes, absolutely. And I think as a mediator, I like to leave people on a high note, even if the matter has not actually resolved. They've learned something, even if they've learned what the obstacles are. They've gotten new information, and I try to set a time by which, if they need other information, I will get back with them and keep this conversation going. My job is to keep the conversation alive. So yes, I would have to agree with the something I think Jeff or maybe it was Neel said at the beginning. We are finding that the mediations are not necessarily actually resolving the case in that day, but it doesn't mean the mediation is over. And I think it's really incumbent upon the mediator never, ever, ever to let go.
And Jeff,
until you expel us.
I know, Jeff, you never let it go, but let's move a little bit. Tell us some new techniques that seem to be working in this environment. Maybe you might want to comment on joint sessions, which I know don't happen too frequently in Southern California, or opening sessions. Have any comments on that?
I think, as I mentioned earlier in the webinar, Ruth, I think they're happening more often because people are more relaxed. They're less tightly wound, both as speakers and as listeners, when they're participating from their home environment. I think that one of the responsibilities of the mediator is to try to design a joint session that is designed to produce progress rather than antagonism to the maximum extent possible. So we have the benefit of reading both sides' mediation briefs. We have the benefit of the confidential conversations with both lawyers before the mediation. And we start to develop a sense of where the rubber really hits the road here. What is the real keystone issue? And you try to design a joint session that addresses that, so that it's not simply saying, well, Mr. Evans, what do you think? Mr. Chatterjee, what do you think? And then letting these very fine advocates do their soup to nuts advocacy thing. That will produce a lot of antagonism and probably not very much progress. But if the mediator can look at it and say, okay, here's what's really keeping people apart here. What is the proper measure of damages? What really is the smallest saleable patent practicing unit? Is it, or in a more simple sense, are we talking about an out-of-pocket measure or a benefit of the bargain measure? Or are we talking about whether a piece of evidence is likely to be admitted over a hearsay objection or not? Whatever it is, if we can isolate one or two keystone issues and say, okay, my friends, these are the issues we really need to discuss. Let's please limit ourselves to those issues, and we stay away from things that are highly inflammatory. Then we can have a discussion in a joint session that I think is much more likely to lead to progress. And the place where it leads to progress is in the caucus, which immediately follows that joint session, where it looks like we're having a conversation and not an argument. We can go into that caucus and I can say, okay, Neel, we were in that joint session and you heard Terrance had XYZ to say about your arguments. What do you think about that? And then Neel and I are having a conversation with his about these issues in the presence of his clients, and they can listen, and perhaps some of Terrance's good points will sink in. On the other hand, Ruth, if we have not had that joint session and I simply go into a caucus and I say, Neel, I see you're arguing 1, 2, 3, and I've got Terrance's brief here and it says XYZ, what do you think? What do you think? What do you think? Then it looks like I'm arguing Terrance's points. It looks like I'm sponsoring his arguments, not like I'm just the narrator of a discussion. And anytime it looks like I'm getting into any mediators getting into an argument with a lawyer in the eyes of their client, the mediator always loses that argument, always, because the client understands that their own lawyer is their champion, their zealous advocate, their fiduciary, and the mediator at one level or another is just the person who wants to see a deal. So by having those tailored joint sessions followed by caucuses that look more like conversations and less like arguments, we can generate a tremendous amount of progress. And trust me, it's easier to do that in the online environment because, again, the joint sessions tend to be less antagonistic when people are speaking from the comfort of their own homes.
I was just going to add very briefly, one advantage that we've seen with the joint sessions is that sometimes if you're concerned that the other side is filtering information to the party on the other side, and there's a message that you really want to convey, you're able to do it during that joint session without fear that the other attorney is going to filter it in some way where that message is not communicated effectively.
And sometimes, Terrance, what we're finding is that we can get a joint session, but the clients, you, for example, may be concerned that your client will have agitated facial expressions or whatever. So the client participates in the joint session, but with their camera off, so that they can listen and hear everything you have to say, but you don't risk having their inflamed or antagonized reactions broadcast for everybody to see, which might set the process back.
Okay, we just have a couple minutes left. I just want to ask, I'll start with the litigators first. Any best practices that you've seen mediators engage in that have been effective? And then I'll ask the mediators. Neel, why don't you start?
Yeah, so there's one thing that a mediator had done with me relatively recently that I really, really liked, which was at the very beginning, there was the joint session where everyone gets reminded of confidentiality and the like. And the mediator asked every single person to say a little known fact about them. I found that was really good because it kind of broke the tension of the initial thing and it started a more personal connection and relationship. And we didn't settle that day, but several days later when our client called the other side, there was already a common ground based upon these, little known facts that could start a conversation on a friendlier foot. And I think that's a really good thing to don't forget the human factors when you're going into these things.
Yeah. Terrance, any thoughts?
Yeah, I was just going to say one thing that I found very effective is when the mediators have done their homework. I've had mediators who got to the mediation and they said, you know what, I didn't really have time to read through the briefs. Can you tell me what this case is about? That's not effective. But the effective mediators, they've done their homework. They call in advance and say, you know what, there was this one issue I didn't quite understand. Can you explain it? When all that communication and preparation happens for the mediation, you're ready to have a good negotiation.
Okay, Rebecca and Jeff, 30 seconds each on good things litigators have done.
Attorneys' credibility is absolutely key. One of the most effective things I've seen in joint sessions is a very well prepared advocate who will identify and acknowledge the weak points in their case and explain exactly how they're going to get past them and what they're going to do, and then move on to the strengths of their case. Very, very effective.
Okay. Jeff? Closing
humanize,
comment.
humanize it. I can't say more strongly than Neel did, and it's easier at home. I see that Neel's got a musical instrument in his background. He's got pictures of his children in his background. The artwork that you see over my shoulder was done by my father when he was a college student in architecture school. So allow yourself to be a full human being. It helps to get the demonization out of the litigation process. And when we can communicate genuinely as human beings to each other, we're not only going to make more deals, we're going to make deals with which we're much more satisfied going forward.
Well, I think this has been an extraordinary panel, an extraordinary hour. I think any dispute that came before us, the four of you have it figured out very quickly and economically through using Zoom as we're doing these days. I want to thank the panel so much.
Thank you, Ruth, and thanks
you,
to
Ruth.
everybody. Thanks to the California
you.
Lawyers Association,
Yes.
too.
Thank you, California.
Thanks, everybody.
Association.